Hey, well, good afternoon or good evening, everybody. This is Patrick from the Poison Pen Bookstore, and we're here with another of our virtual events. And we're really excited to be here on publication day for Robin Peguero's new book, With Prejudice. And congratulations, Robin. Very exciting.
Thank, thank you so much. I appreciate it.
Yeah, and so Robin very kindly signed a bunch of books for us, and we still have some signed copies. I will go ahead and put a link in the comments field on Facebook and YouTube, should you wish to purchase one. And get your questions ready for Robin if you have any. Don't be shy. I will reemerge towards the end of the hour and be happy to ask any questions you might have. So there's somebody named Michael who just entered the waiting room. So we don't know him, but is he one of yours, Robin?
Could be. If it's Michael Nardullo, that'd be my agent.
Oh, okay.
Ask him to, Michael, we'd love to have you in here, but in point of fact, please go to Facebook, Poison Pen Facebook page and click in there, and then you can watch us do whatever we're going to do.
There you go.
Perfect.
All right, so Barbara, over to you.
Thank you very much. This is actually a debut legal thriller, a debut novel. I love those. It's always exciting to talk to an author at the very outset of their career. And this is the outset, because in fact, this is publication day, as Patrick said. Normally, I would have a glass of wine and drink a toast to Robin, but today it's only going to be tea, Robin. But as doesn't mean a thing other than congratulations.
Thank you. Cheers, nonetheless.
It's just fun. So it's always difficult to do an event for a book when it first publishes, because the good stuff you'd really like to talk about, we can't, or there will be hideous cries of spoilers and hatchet men coming for us and the whole bit. So I think we should start by Robin's own personal story, which is really a fascinating one. And when you hear it, you will realize the authenticity that it in fact lends to his book. So Robin, who are you?
Yeah, so I am a first-generation American. My parents came to this country, emigrated to this country. My mom was 17, my father was 24, from Latin American countries, Dominican Republic, my dad, Ecuador, my mom. They met in the US Army, fell in love, got married, had my sister and me. And I grew up the first 5 years of my life in New York, but then I moved down to Miami, which is where the book is set. And I lived there in Miami up and through high school. Went back up north for both college, worked in Washington, D.C. on Capitol Hill for some really great members of Congress, and then right back up to Boston for law school. And it was after law school that I decided I would come back home to Miami and become a prosecutor. So I was in the Miami prosecutor's office for 7 years. The last 3 of which I was a homicide prosecutor. And that's where the idea for With Prejudice came from. It very much is fiction, clearly, but it's based on my experience as a homicide prosecutor, trying cases, working with victims, trying my best in pursuit of justice. And those were an interesting, trying, tough, tragic, but exhilarating 7 years. And I've only just recently stepped away, returned back to DC to work in the House of Representatives. But I still have very fond memories of those 7 years, and allowed me to birth this book. So I'm quite grateful for that opportunity.
Robin has lighted over the fact that when he went up north to college, he actually went to Harvard. So Harvard College and Harvard Law School, which is certainly a distinguished record. And he's also written for multiple publications, including the Miami Herald, the Harvard Crimson, and the Harvard Law Review. And if any of you know anything about law school, to actually be able to write for the law review of your law school is a significant thing. So you must have been a better than average student, Robin.
I try my best. I've always loved reading and writing, and thankfully that helps you in law school and as being a lawyer. So I've been grateful.
So decades separate you, but did you ever read Scott Turow's wonderful book 1L about his first year at Harvard Law?
I don't think I ever actually read it, but I think I saw some multimedia that was produced afterwards. I've read Presumed Innocent, obviously that sort of canonical legal thriller book that I think we all owe it to him, everyone who's come after him. But I think I've seen media representations of 1L. I don't know that I've read the book.
Well, you really should. I mean, it's It's fascinating. And of course, it's a memoir. It's not a novel, you know,
Right.
although I think that it was a springboard to Scott then deciding that maybe it'd be better to write books than practice law or do both, which is what he ended up doing. I read the law in Virginia, so I am in a peculiar status in that I can only practice law in Virginia because if you don't go to an accredited law school, you're not allowed to practice in the state that, you know, where you didn't do that. And then it got more complicated than that. But so I don't know going to law school personally, because I didn't actually do that. But I think that, would you agree, Robin, that the training that you get as a lawyer, whether you ever practice or not, the problem solving training, the forward looking thing, the, you know, finding solutions to problems, often mostly anticipating them, is a really great platform on which to build a life, whether you practice law or not.
Oh, absolutely. And I was grateful, you know, all those horror stories from 1L. I didn't experience a super competitive environment at Harvard Law School. I think what also helped me is I had taken 4 years off in between college and law school. And I knew, you know, people aren't poring over necessarily your exam grades. You know, it doesn't actually matter too much once you leave, especially with a degree from such a prestigious and reputable school. The sort of day-to-day stressors of this grade and that grade and trying to do better than your classmate, it didn't impact me or a lot of my colleagues who didn't go straight through, who sort of took some time off and realized that was maybe not an environment that, you know, that we wanted to partake in. And so I, you know, had really great friends, made really great people who were supportive, and I myself didn't feel that sort of hyper competitive atmosphere that I know some people have, and especially I think in the past at Harvard Law School, I think they've done a good job of trying to make it more collegial. Yeah, I think the skills that you learn there incredibly you know, critical, important, helpful in being a lawyer, and I think in being a writer as well. You know, being able to sort of reverse engineer your way through problems, you know, that a lot of that is how you put together a story. You know, sometimes you kind of know where you want to go, and you don't know how to get there. And you have to be able to sort of map that out. And a lot of law school problems was about sort of how you reach the answer, not necessarily what answer you reach. And so I found some similarities in those two. And thankfully, I think that the experiences that I learned at law schools helped me both in being a lawyer and now in my writing career.
Well, you certainly know, having done a lot of courtroom experience, and hilariously, I mean, not to make this all about me because it isn't, but because I read the law and I didn't have to, I could choose what I wanted to do. So I know zero about corporate law. I mean, tax law, forget it. But because the program allowed the judge that, or whoever you were working with, to qualify you, and a judge in a court to qualify you to do whatever they thought you were capable of, I got to do a lot of trial work because there was no legal aid in Southwest Virginia in the late 1970s. And so they paid like $50, you know, for a capital case or something. It was just ludicrous. So, because I was a student, I worked for free, right? And the judge could say, she could do that. And what you learn if you spend a lot of time in court is that, and especially then, before there was so much forensic evidence and juries decided, you know, everything was going to turn on DNA or some such thing, the best story was the one that resolved the case. And, you know, flying in the face of facts, very often you could convince a jury if you were a real tail spinner as a lawyer. And so I find it, I'm not sure it would be that much fun anymore to try cases, because I think that factual evidence and forensic evidence may have cut back on the power of storytelling, but I don't really know that. What's your experience? Do you think it still works?
Yeah, I love what you said right there. That's in essence, you know, what I took away so much from the criminal justice system. It was that people think of it as sort of objective fact, whereas really it depends the lenses through which you're seeing those facts and your life experience, your own biases, your own prejudices, not even negative ones, just what you've gone through in life. They affect what you're looking at, and two different people might come away with two different impressions. You know, I like to talk or think about the sort of Rodney King beatings that were captured on tape. People will see the exact same footage and see a man resisting arrest, and others will see police brutality. And so sometimes even things captured on video, there is no objective fact. People are still informing their opinions and thoughts about those facts through what they've experienced in their lives. Has it changed since, with the rise of DNA and forensic evidence? We try our best to, during jury selection, tell the jury that, this isn't going to be CSI Miami. You're not going to, have such imprecise evidence that, caught on camera in the reflection of the lens of the person was the killer. Nothing like that. Don't expect these, DNA or forensics or fingerprints in every single case, because not every case either requires them, not every case would it make sense to have that type of evidence. And I like to talk about, how did people convict people 200 years ago when we still had the same, standard of proof? It was, as you put it, it's stories. It's your neighbors coming in, raising their hand, swearing an oath, and you making a credibility judgment as to whether they have any reasons, motivations to lie, any biases, any reason that they would want to, take out a day from their jobs and often come to court for, come to depositions, give statements, to face cross-examination. This over the course of, often because of how slow our criminal justice system can be, a year, 2 years, 3 years, why that person would want to do that just to come up with a story. And of course, there are certain witnesses who are, interested parties, but many are uninterested parties, are objective observers who have no reason to lie. And so you try to convey that to the jury right from the start, that this is a matter of just making credibility judgments. And you hope, as you put it, sometimes you said, whoever spins the best tale kind of ends up winning. You hope that, it isn't all so arbitrary, the oral skills of the attorneys. There's some research that even the attractiveness of the attorneys sometimes affects who the jury believes, who the jury trusts in terms of the different versions that are being presented to you. And so you want to hope that it's not that arbitrary, but that's what I came away with, the idea that, for better or for worse, we have a jury system of human beings. And in the end, there's going to be a lot at play that you can't control as to how that verdict is going to turn out. And that's, it's very human, the system we have. And, I just want people to be exposed to that, to know that about the system, because it's so often presented as cold, hard facts and nothing else.
Well, you have a lot to say about juries, which we can get into, but it's interesting that you use the Rodney King trial as an example, because it was I don't want to say the word out. Anyway, it was a cluster, as we all know. And one of the lead attorneys is a friend and an author. She said to me that once the judge did not grant a change of venue, that trial was lost, because the jury pool that was going to be available for trying the case in Los Angeles was always going to be that pool who saw it as police brutality, or who saw it as an opportunity to protest, regardless of, and it's, we're seeing so much of that today, where people flying in the face of reason, or just taking in information from the narrow channel that, happens to agree with them. So, I think the Rodney King trial was, in fact, the O.J. Simpson trial is actually what I'm thinking of. Not because of Rodney King. I'm sorry, I got all confused. Because of the Rodney King trial, the O.J. Simpson trial was the one that was not ever going to work once, I apologize, I screwed that up, was not going to work once it was taken out of the same areas the Rodney King thing had happened. And I think you point that out very compellingly in your book, because you don't have a whole universe of jurors. You have the jurors in the jurisdiction of the court, or in the community that the court operates in, and they can be wildly different. You have a fairly cynical view of juries. And I find it interesting that one of the statements you make in the book is that trials basically decided once the jury is impaneled. Once what's called in law the voir dire, which is French for to see and to say, and is often pronounced for dire, and dire it can actually be. But once that's over with, and you've got your jury and probably a couple of alternate jurors in case somebody drops over or aces out or whatever it may be. That might really be the case right there, which is the O.J. Simpson case that I was referring to. So how did you come to that interesting decision, which you write into your book?
Well, just practicing. So many of us can get an inkling after you choose the jury. I remember one case in particular. Right after finishing it, selecting the jury before any evidence has been presented. I thought, okay, this is likely going to be a guilty, and it ended up being that. Juries can surprise you, of course, but who they are is really what decides cases more so than what you're telling them. And again, it's because, you talk about, and especially that phenomenon now, people are sort of entitled to their own facts in a way. We have all these major cultural debates about climate change. And you sort of, take in the facts that confirm your own biases, you kind of disregard the other ones, and then people just get more entrenched in their positions. Vaccinations and masks have sort of taken on that same sort of cultural valence. People have different cherry pick facts. They view those facts through whichever lens they've grown up with, whatever their politics are, and that ends up deciding where, what camp we follow. And I came to feel that after practicing, that so much of it was, who are these people? And we're all kind of tiptoeing around wanting to ask just direct questions. I like to think, and I think it's maybe a line in the book, that the most direct question you could ask is, who'd you vote for in the last election? And that kind of gives us a lot of information as to how conservative, how egalitarian, what type of person it is that we're selecting there. And there are going to be certain cases that are going to appeal more to conservative minded people. There are going to be a lot of cases cases that progressives tend to see as under-enforced, like violence against women, potentially gun crimes, ones like those, hate crimes against minorities. Those are going to appeal more to liberally minded jurors. And so it is all about trying to find the juror who's most sympathetic to your case. You still have to present the evidence. And so I'm somewhat cynical, but not entirely. I believe in the criminal justice system. I wouldn't have, I think, participated in it for so long if I thought that it needed to be sort of torn down completely. I think what motivated me to get involved was that I think it needs a lot of changes, a lot of improvements, but that I could do it sort of on the margins within the system, tried my best on the position, the side where all the power is, prosecutor side, where people like myself and people who look like myself aren't always necessarily drawn to. And I thought that was important to have a diverse prosecutors representing the government, representing the state, and making those informed choices about which cases to move forward and which cases to dismiss. So I'm not all cynical, but I do think that that's a lot of the game. And it is a little bit of a game, especially jury picking. It's about burning, vetoing people, and that side vetoing people until you hopefully get a group of people as sympathetic as you can. Hopefully not people who are unbiased to the point of having zero opinions, to the point of not being well-read, to the point of not being knowledgeable, to the point of not caring. But I think that you sort of get stuck with what neither side kind of really wanted, and it's just about trying to figure out, are those people who are sympathetic to your cause, to your side, can you pull them over, can you convince them? It's all a little bit of gamemanship, which is scary in a way.
There's it's really very interesting, and The State Wears Heels is an early chapter in the book, and we meet Sandy Grunwald, who is in fact going to be the prosecutor, and her view of jury selection. I mean, you really set up this book in this chapter, I think, in a way, she's sort of throwing over her shoulder wisdom to her intern about jury selection as she goes along. And I liked your example. As a novice prosecutor, Sandy had once ecstatically chosen a jury of all women to sit in judgment of a college freshman who had held down a girl against her will and ejaculated on her back. And what Sandy realizes that she should have had men on the trial because the women were thought that this girl had been so naive to invite the guy into her room that they weren't willing to cut her a break. Whereas if there'd been a man, it might have rallied them to think about, women in jeopardy. So I think it's really true that I was at one point in my life the plaintiff in a major medical malpractice trial. And I had learned, and I'll get to that one after a while, I had learned how important impaneling the jury, going through the voir dire or questioning process really is. My attorney, because you should never represent yourself, wanted all men on my jury. He felt that I would be a totally unsympathetic plaintiff to women. And I thought that was just total bullshit, given the nature of the case, which I won't get into. So I sat in, and we ended up with 8 women on the jury and 3 men. And in the end, not only did they find for me, which is really unusual because you really have to die in order to get a very good medical malpractice verdict, but they gave me a lot more money than we sued for, which nobody ever noticed till the end. And I wouldn't have done that if I hadn't had previous experience with how important it is that the lawyers pay attention to the jury pool and do the best job they can. And this was back in 1980 when, it was all a lot similar. And I still remember looking him right in the eye and saying, no, we need women. And, I would think, you're a person of color and an immigrant. So, you would obviously you wouldn't want somebody to say to you, no, we have to have an all white jury, or we have to have an all black jury, or we have to have, Miami's a different community than Boston. So right there, you would have found some differences.
Certainly. And, that's a good lesson in lawyers are, they're not the principal. The client is the principal. As a prosecutor, the client for me was the state of Florida. It was justice, it was truth. But in that case, of course, your attorney really is supposed to be speaking on your behalf and counseling you, of course, and maybe giving you advice as to why he or she, I think it was a she, right? Thought
it was particular. A he, and I was the she. And it wasn't that he was not, he didn't respect me. He just really didn't get it, and we were a lot more patriarchal in 1980 than we are now. It doesn't seem like it's that much time that has elapsed, but nonetheless, it has. But very few people represented by the defense know enough or have enough courage to speak up when they feel like it's not going well. And that's one of the interesting things about your book, is to what degree is the defense attorney manipulated here by his client?
Yeah, I know. I think that in literature, often I think the defense attorney is sort of lionized, and for good reason. It's a very noble profession. It's a profession that I think I find myself more naturally inclined toward. I was actually the president of the defender organization at law school. So that was what I felt more naturally inclined to do. And I think because of what we were talking about a little earlier about how much the power is in the prosecutor's hands, and me trying to do good on that side, I decided instead to be a prosecutor. But I think in media, the defense attorney's role, especially for progressives, is sort of lionized and sort of made heroic. And often the prosecutor is kind of maybe the more sharp, manipulative, potentially darker character. And what I wanted to be fair to both sides in this book, because I think both are very conflicting. It isn't necessarily always easy, I don't think, to defend a client, because you're looking out for the best interest of that person, not necessarily the best interest of society, what's good for public safety. You shouldn't be concerned about whether your client is innocent or guilty, in terms of how that really should affect how zealously you defend the person. And so, you can be sometimes, I think, manipulated by your client in certain ways. I do think it can be conflicting. I do think a lot of what you're doing as a defense attorney is tearing people down, right? You're trying to cross-examine, to make witnesses out to seem like they're either liars or they have credibility issues or they're holes in their story. And that's part of the deal. That's part of the job. But depending on who those people are, again, defense attorneys are people too, especially if they have progressive politics. That can sometimes mean a rape victim. That can sometimes mean, people who have been victimized, the elderly, or people who have been abused, people for whom usually that progressive, of course, feels very much sympathy for. But part of the job, it's a performance, is to get up there and to attack that person, obviously, respectfully, but to poke holes in that person's story. And so I wanted the conflict to be as clear, and I think it is for Sandy as a prosecutor, as a progressive prosecutor, still trying, to put someone in custody, as it is for Jordan, the defense attorney, trying to grapple with the idea of defending someone, and what does that mean, and what tools can you use, and what's walking up to the line, what's crossing the line. I think there's a lot of those questions surrounding both sides that are fascinating.
We have to realize that the English common law system really arose out of duels. In fact, the best example of that would be Richard II, Shakespeare's play, in which you can see the duel very clearly laid out. And really, that's what it comes down to in court, is the idea that if you have a prosecutor and a defense attorney, both of whom could have been guys on horses with lances and armor and so forth, that in combat, eventually, they will arrive at the truth. But that gets complicated by a lot of things. I've always thought that the high bar for me is that if I had been a defense attorney, would have been if I knew my client, or I was reasonably certain that my client was guilty. That person deserves the defense, but I would find it extremely difficult, to argue for them. And life is not all Perry Mason. It is not always the case that, your defendant is innocent. Very often, in fact, the odds are that your defendant is guilty. I don't know, I read something the other day that said probably somewhere between 85 and 90% of people brought to trial actually are guilty, but that might be high. I don't have any idea whether that's really true or not. And it doesn't allow extenuating circumstances, can also, because there are shades of guilty, right? I mean, there are various layers that, or not layers, what's the word I want? They're how do you describe it? Murder has, or the death of a person.
Severity, degrees or severity.
Exactly, that's a degree. Oh, sorry, I blanked out there. Right, so you can go all the way from justifiable, homicide to self-defense to, and we did an event Friday night with an author who's written a book called The Murder Rule. And she's an Irish attorney that now lives in Australia, but did a legal thriller, interestingly enough, studied at the University of Virginia in Charlottesville. And it involves a girl who joins the Innocence Project, a law student, enrolls, or actually fake enrolls at UVA to join their Innocent Project so she can sabotage a project that they're doing for personal reasons, which I found really interesting. But at some length, they go into what the murder rule is. And, did you ever actually try a case where the murder rule prevailed? I mean, like, let's say the guy was, the driver for a bank robbery, and the robbers go inside and, wind up shooting the security guard or something, but the driver of the car, who never entered the bank and didn't have a gun, is just as guilty, or is sometimes actually hammered harder than the guys that were shooting the gun.
All right, yeah, so we call that the principal theory in Florida. So okay. You are treated like a principal if there are certain things that you have to both have taken sort of an overt sort of act or step in the commission of the crime, and then you have to have a conscious intent that the crime be committed. Thankfully, definitely I've tried a lot of cases where we were operating under the principal theory. I can't recall right now whether it was a murder that I've tried, but I think I've certainly pled out cases in which, the driver is the one who drives a person up, watches the robbery take place, the person died over the course of the robbery, was shot over the course of the robbery. He gets back in the car, he drives off with him, he helps him, conceal the car, the weapon, so on and so forth. And so kind of from beginning to end, he plays sort of a pretty major role. And yeah, no, we have that. And I think, so in terms of severity, sentencing is a lot of where, that sort of stuff can be taken into account. The fact that maybe he's not the triggerman, that maybe he's the driver and therefore has less responsibility or less of a role to play. There are sometimes mandatory minimums constraining judges. And so that can be problematic because, again, sentencing might be right strictly legally that person should be convicted of murder. But it really should be up to the judge then to decide how much culpability that person has and what sentence is appropriate and what isn't. In terms of, people being guilty, I do think that I certainly, thankfully, have not tried a case that I didn't believe beyond a reasonable doubt the defendant was guilty. If I didn't believe it, we would dismiss the case, and that's across the board how we tried cases in Miami. My boss she still is there, but no longer my boss. But she was a great boss and very fair-minded, and that it's a very good city. I get a good office about that sort of thing. So I felt confident in the guilt of everybody I was trying. And so I think often defense attorneys know that there is some level of culpability, right? I don't think that a prosecutor would necessarily take a case that is, if not at least arguably provable beyond a reasonable doubt. Again, juries can have different interpretations of the facts, and so too can attorneys. But I think what they would say is that who knows whether the actual charge that is being brought, whether their client is guilty of that, because it's a very, the standards are there are elements that you have to meet. And it could be that everyone kind of knows maybe that this person committed or did something wrong, but maybe not that particular crime. He's charged with burglary, let's say, and the defense attorney thinks, okay, at most it was a petty theft. So I think he's innocent. I'm going to argue that he's not guilty to the jury, even though he has some level of culpability. And so, I think there are, as you said, gradations. There are differences in degree. I think defense attorneys absolutely, and it's part of our system, try to secure acquittals through jury nullification. They know legally, and they believe that likely legally, even a jury will understand that the person's guilty. But they'll say, I feel bad for him, or I think, I want to pardon him. I'd like to extend mercy and nullify. And so I wrote a little bit about that in law school. I think nullification is super fascinating. The idea that, you come to a not guilty, and you can come to a not guilty in any way. And that's sort of another meaning for with prejudice. Verdicts, not guilties, are with prejudice. They're final. They're not guilty, at least. Guilties are not final. They can be overturned, obviously, because of the severity of them. Judges, higher courts look into them. But a not guilty is done and said, and nothing can be done afterwards. Even if you come to learn the jury, let's say they said, I acquitted the person because of their race. I acquitted the person because of the race of the victim. Cannot be overturned. So even something improper, we allow juries that once they extend the mercy, it's done, it's over with. And because of double jeopardy, never can that person be tried for that again. And I find that fascinating. We leave it in the hands of the jurors. We tell them up front, you can't nullify. But in the end, I know it to be true. Everyone knows it to be true. All trial attorneys, juries often nullify and will nullify. And that's just a feature of our system.
I think you do a very good job of explaining double jeopardy and the consequences as we get to the end of the book, which of course we're not going to talk about because we can't. But you do have a big statement here on page 13, which is Sandy speaking, and she says, I think it's Sandy anyway. One thing I do know, although the heavy lifting is about to begin, the most consequential part of our work is already over. The evidence will shift those 6 minds very little. The verdict is more or less written in stone. And there again, it comes back to the importance of attorneys paying attention to impaneling the jury. Now, this is my story, which you will really love, because my very first appearance in court as a somewhat terrified baby law student was in a small town in Virginia. The city attorney was a veteran. I mean, he was an older guy and big guy, used to winning and everything. The judge was a fairly young guy that I knew pretty well. My husband, my then husband, was the real lawyer. And he was actually up in Grundy, Virginia with David Baldacci doing some, because David did some practice up there in the coal country. Anyway, he couldn't come back in time for this trial to start at 9 o'clock in the little city courthouse. So the night before he called me, he said it was a kind of little pro bono case, and it involved a guy that was a contractor. And the issue at stake was whether the guy that was driving the bulldozer that caused the problem was an employee of the general contractor, or whether he was an independent contractor that got hired. And there are reasons why that is important. So he called and said, my client, thinks he's screwed. There's nothing, this is, gone on and on. So he won't care if you lose. I can't get there. I'll get there at the end to sign off. So I want you to show up and represent our client. So I spent the night in the law library, and I showed up at 9 o'clock in the court and sat there quietly, and the jury came, the panel of juries was there, and I looked over at them. The city attorney looked over at them, and he thought, this is such a slam dunk. She doesn't know what she's doing, and I'm going to win this case. So he didn't bother to question the jury at all. He just took, whatever. And I thought, well, George isn't going to do it. I certainly won't question the jury. So they put on the argument, and George went ahead, with the case for the city. And then he rested, and the judge looked at me and he said, Mrs. Peters, he said, do you ready to speak for the defense? And I said, well, Your Honor, I said, I'd like to present a motion to dismiss. Judge kind of blinked. George looked kind of surprised. So I marched up there and I handed over my motion to dismiss that I had written in the law library. And the judge looked at it, and he looked at the bailiff, and he said, bailiff, he said, you need to dismiss the jury while we consider this. So the jury all goes out. The judge reads the whole thing, and then he goes back in his chamber where we could hear him laughing. And then he came back and he looked at George, and he looked at me, and he looked at the bailiff, said, call the jury back in. And so the jury came back in, and the judge said, thank you very much for your service. He said, but I am granting the motion to dismiss. So George is looking stunned. My husband has just arrived. He has no idea what's going on. And as the jury arises, the foreman of the jury walks up to me and puts his arm around me and gives me a big hug. And he said, Mrs. Peters, he said, that we were never going to fight against your client. Oh, oh, thank God, that I actually won this thing another way. But my point is that everyone thought, there was no need to question the jury. And, I certainly wasn't going to, make it clear that I already knew the foreman of the jury. I didn't have any idea he felt that strongly, but
right.
it stayed with me for good. And I thought, no matter how trivial your case, no matter how confident you are, you cannot afford to take anything for granted. You really have to do your job. And one of them is, in fact, getting the best jury that you can possibly get.
Yeah, no, that sounds like malpractice for the opposing counsel to not even, lift a finger or stand up and question the jury. I've come across some defense counsel who I could tell weren't either trying.
Well, it was a pretty small stake, let's face it. We were just talking a little money here. I'd like to think if it were, and we wouldn't have been in city court anyway if it had been a more serious case. But, and of course, I forgot to mention that the judge, when that happened, dove under his desk. He was laughing so hard. It was really funny. But as a result, I got to do a lot of trial work in Virginia because I had an undeserved reputation, which I hadn't actually earned. It was overconfidence on the part of the rest of it. But I think it, when you're a veteran in something, it's easy to take things for granted. It's easy to think that, you've got a slam dunk or whatever it is. And George was betrayed by that. He just, thought he could just glide right over it. And I don't think as a prosecutor or a defense attorney that you can really ever do that. And Sandy, she's such an interesting character here. And her duel, of course, is with the prosecutor. And lots of stuff happens, none of which we can discuss. But Sandy is really paying attention every step of the way in this book. She is an incredibly conscientious prosecutor.
Yeah, I wanted a prosecutor who cared a lot about her job, who is sort of meticulous. I wanted them to be, worthy adversaries for one another, the defense attorney and the prosecutor. I do think there's a lot of, sharp give and take, a lot of arguments that hopefully are sort of relatable and not get carried away with too much legalese. And then there's, cross-examination and directs that I think sort of speed and move the book along, because that was the most exciting part of being a part of a trial. I wanted to sort of replicate that feeling of the sort of nerves, nerves before a verdict, nerves before you're about to go up and cross a witness. You mentioned, adversary and battle. It very much is an adversarial process. And so it was ripe for drama, I thought. We wouldn't eat on trial days. Usually my trial partner and I, you would sort of skip lunch. It would be a ball of nerves, really. And the adrenaline would just keep you going, would keep you up. And it is active listening. It's so physically exhausting to actively listen to every single question, because even when you're not doing the questioning, right, you have to be prepared to object when you believe the opposing counsel is getting out of line or treading into waters they're not supposed to legally. And so, I really wanted to make sure that the two sides, that they were worthy adversaries. They were really good at their jobs, that they really cared about it, to the point where, for Sandy, she's a very strong woman who cares about her career, who's very ambitious. For her, she's a perfectionist. She really, pushes it to the limit. And I was always impressed with people who do that, who commit themselves, because the stakes are incredibly high when you're a prosecutor. You are trying to do good by the victim's family, by justice and what's true and what's right. You're trying to do right by the defendant as well. You're trying to make sure that you're putting on your case as best as possible, because it could mean somebody who you believe has committed a quite heinous crime and who may be dangerous to other people, not being held accountable for that crime. And so I think it matters a lot. It's important work. And so I was glad to have a character who thought of it that way and cared that much about it, so that we could follow her and hopefully also develop that same care in what happens in the trial.
So you open the book with a short chapter involving driving by black, and it turns out that the police officer who is in fact harassing the driver is black himself, which I found really interesting. But what is the case that is the heart of this book? What is it that Sandy and the defense attorney are really arguing over?
What are they arguing over? Well, about that little vignette, I got tickled by it myself. I think I sort of actually stumbled upon that little twist myself. And what I was trying to communicate is that often things aren't what they seem to be. People have many different identities, right? And so sometimes we think of certain identities as being salient, maybe race being the most salient. But it could be that a police officer might see that, a black police officer might see that as a big part of his identity. He may be conservatively minded. He might be sort of, support the blue line, that sort of thing, and potentially, have mixed feelings about the other side, about Black Lives Matter, so on and so forth. I just thought that was a very interesting way to capture the thought that we're very complex human beings. And sometimes people have power, and people even in positions of power who are minorities, who you might not expect to have either certain politics, certain beliefs, or act in certain ways, can act in ways that conform to other parts of their identity. So I found that really interesting. I think ultimately what the two sides are battling about here, they're not battling over truth necessarily, because that isn't within Jordan, the defense attorney's role. It doesn't matter to him necessarily what truth is. His job is to, if it is, to obfuscate the truth, is to throw roadblocks in front of the truth, to try to paint a picture of reasonable doubt. Certainly that's what Sandy's fighting for, but she has her own personal ambitions and reasons why she's trying to secure a conviction. And so maybe, although I think, certainly I think both are doing a noble job. They're, one is defending somebody and requiring that the government bring a certain level of proof, and it needs to every single time in order for our system to work. We can't let it sort of shirk their responsibility of the state and not put on the best case possible. And although I think Sandy's also doing right by justice and what's true to her and what she believes happened beyond a reasonable doubt, it's also true that they are sort of, these high-powered kind of attorneys, overeducated, self-interested. There's a little bit in the book about how at a certain point the defendant kind of fades into the background. People have sort of forgotten that he's even there. And I came away sometimes feeling that they're so quiet, and it becomes this game between two attorneys, these two overeducated, usually young, because prosecutors and public defenders, they tend to be young, in their 20s, handling these sort of really important cases, arguing sometimes over case law, rhetorical flourishes, performing, just as you put it, how orally are they doing? How much of a storyteller are they? Can they spin a tale in front of the jury? That you sort of forget that there's a person here who's committed a heinous crime, and you sort of forget the victim too, often, unfortunately, because by design, you can't really talk a lot about, I'll just use her, since the victim in the book is a woman. It's hard, they don't let you talk necessarily about what a great person she was. They don't want you drumming up sympathy. And so sometimes you'll go through a case 3-4 days, the jurors know very little about the victim other than her name and the fact that she was killed. And it sort of becomes true for the defense attorney too. It becomes these sort of two major personalities, the defense attorney and the prosecutor, sort of bloviating, hearing themselves speak, debating, gamemanship. And that can feel kind of demoralizing. That can detract, I think, from ultimately what we're supposed to be there, which is, I think there's an expressive function to a trial. We're there to figure out the truth. We're there to hold somebody accountable, and not necessarily to see the sort of this lawyerly show between two people who are just using rhetoric, to talk themselves up.
This is a criminal trial, not a civil trial. So in criminal trial, there are serious penalties attached, like prison time, or in some cases death row, whatever it is. What is the defendant charged with in this case? What is the crime then he is being tried for?
Yes, premeditated murder, first-degree premeditated murder, as well as what we call attempted sexual battery, I believe, in Florida, which is our rape statute. But death penalty is not on the table in the book, and so often the prosecutor's office either waives the death penalty or doesn't pursue the death penalty, that sort of thing. Because if it's not a capital jury, it's 6 jurors in Florida, which is very interesting. So I think I've only tried cases in front of 6 jurors before. I've never done 12 before, because I know most other jurisdictions were used to seeing 12, but here there's 6 and then an alternate, so 7.
Well, the 6th jury, I mean, I'm glad you mentioned that, because with only 6 people, there's a lot more focus on the individual members of the jury. The wider the pool, the more diluted that gets. So, I think your book is interesting because you do challenge stereotypes. In the opening chapter, it's easy to summon up a vision of Rod Steiger, in the heat of the night or something. And then, there you are, surprised by this officer who isn't the stereotypical white whatever. But, he's obviously, you had a line which I thought was a very good one, when, he never knew when he was walking into a homicide, every traffic stop that he made. So, he's got his issues, and then the guy driving the car, driving while black, has got his issues and so forth. I like, so many legal thrillers are written by white attorneys. I think that you're bringing an interesting perspective to this. And I wanted to ask you one final question, and this is just my own ignorance, but it has come up. I do not fully understand the term microaggression. Can you explain it to me?
Sure. So I think the idea of microaggression is that it is small, sort of, and I think there's I think I use the word slicing through somebody. It's a little bit, kind of when you have maybe an electric pain that's just fleeting, that's in the moment. It's not supposed to be sort of a deep bias or prejudice or racist sort of experience that you've undergone, right? It's not somebody maybe using the N-word or denying you service. Like, those are very big moments that are obviously can be very traumatic and very racist. Microaggressions are sort of throughout your day. Sometimes someone will say something like insisting, where'd you come from? And you're trying to say, Miami or something. And they keep asking, no, where are you from? Where are you from? because they don't see you necessarily as American. Whereas with someone else, their family might be through the generations Ireland, Irish, so on and so forth, but they say Oklahoma and you accept it as fine because you do see them as American. That small thing, one that maybe often isn't necessarily intentionally meant to be malicious, but does sort of cause like a moment of othering or pain or discomfort or awkwardness.
Is it always racial, or can it be gender?
No, I think it could be, yeah, I think it could be any identity that is, again, othering, that is sort of a group pitting one group against another. No, I think there are a lot of identities that we all have that, that we experience those small little daily nicks to our heart that hurt a little bit, but aren't, like I said, very malicious, intentionally malicious, or all that dramatic. It's just something that I think a lot of minority groups, including women, ethnicities, racial, sort of learn to deal with and to live
Or
through and to
age,
smile through.
age has come into play too. I mean, so far nobody's ever actually done that to me, but it could happen at any moment. I don't know. I mean, I'm not a good target for aggression, but other people might give it a shot, or possibly it's happened to me and I've just ignored it because I wouldn't have mattered to me. Anyway, one final question, Patrick, while you pop up, are you working on another book?
Yes, I am currently writing a political thriller set here in DC, which is where I'm working now. I'm trying to, I'm very interested about the Hill. I'm sort of back on Capitol Hill, and I just remember being a young staffer. There's a lot of issues that arise there, same sort of cultural divides that this book kind of treats about race and gender and so on and so forth, but a lot of class dynamics with people on Capitol Hill, and I think it'd be a good setting for another murder mystery. So I'm working on that right now.
What drew you into writing crime as opposed to anything else?
Yeah, I mean, I've written other things, and I hope one day to continue sort of diversifying what I've written about. I've written about my mom, sort of magical realist take on my mom's life. I've written some sci-fi before. In terms of crime, it's just something I know very well, but it's something that's kind of been a through line in my life. When I was writing as a journalist, I was like on the crime beat. I've covered a lot of homicides before. I've been in the same room with people who have been accused of murder way before I was even a homicide prosecutor. So it was a little bit of morbidly, I guess, something that sort of, I guess, maybe piqued my interest. I've been a very early, ever since I was a little kid, opponent of the death penalty. And so the idea of killing, either, stand your ground was another thing that sort of impacted me. I sort of politically feel kind of bothered by justified killings. And so, or that so-called justified killings, because people are quote unquote standing their ground. And so I just think overall, whether the killing is being done on a person by person level, if it's being done by the state, sometimes how it's being carried out is really important to me. Because I think human life obviously is the most important thing that your government should be protecting. And so I just find it very fascinating, all the different ways that we punish people who kill, or we legitimize killing. It's a very interesting and dramatic topic.
Mine was actually in part a craft question, which is that there is a definite structure in crime fiction that is lacking in literary fiction, which is a thriller has a specific structure and a mystery has. And I found that many first-time authors of, new authors anyway, find it easier to have a structure kind of laid out, it makes it simpler. So I didn't know if the structure interested you. I knew the issues interested you, but I wasn't sure if you were drawn to the structure of a legal thriller, which is basically combat, as I said before. You're just in that whole line of Shakespeare writing. Have you actually read or watched Richard II? If you haven't, you should.
I don't think I have. I think I will on your
terrific trial by combat in it, and I think when you do, you recognize, in our legal system, the English common law, there is a presumption of innocence. The defendant is presumed innocent. and the state has to prove contrary. The French system is the obverse. And, it comes from a different thing. And, in that case, the defendant has the burden of proving his innocence. And it's, and the prosecutor is involved in it, in the investigation and so forth. So, we shouldn't universally think, we shouldn't think that the world universally has embraced English common law and the values that we have, because that's not true. There's Sharia law, there's used to be ecclesiastical law, which is a really big thing, that if you are in the highways and byways of historical jurisprudence, you can get lost in for sure. It's, we do sort of assume that what we know is the universal truth, getting back to what we were saying much earlier in this discussion, but it isn't. But I think it is a fair system in the sense that it's better to have to prove someone's guilt than it is to have to prove your innocence. And that's the way we roll here. Anyway, Patrick, are there any questions? I run this up to the top of the hour, so I probably should have shut up a while back.
No problem. Yeah, there are a few good questions here. Let's see. Christina Estes, our good friend, she has a question. She says, Robin, I enjoyed reading your crime reads article. There may be a missing word here. She says, can you possibly summarize how an experience impacts your writing? If not, how about explaining your grandmother's phrase? I'm going to blow the Spanish. El hombre hace, is it deshace?
Perfect.
Well done, Patrick.
That's Arizona for you, right? You guys your Spanish is impeccable. Yeah, okay. Well, I'll maybe take both, but that's my grandma's phrase. And she was always lamenting. It means man gets to create and to destroy. And she meant it man as in man. She meant it as a feminist critique. She felt that, was she born in 1908 or 1913? She's no longer with us, but certainly she felt as though, there was impositions put upon her being a woman, naturally, obviously, that she lamented, that she felt that were sort of inhibiting her ability to be leaders, to get to both do good, create, and get to destroy. And so I always really loved that phrase from her. And I think I sort of quote it in the essay Christina's talking about, because I think I think it works gender neutrally too. That sort of man has this great capacity to do really, really beautiful things. And I mean this man as in again, gender neutrally, humans have the capacity to do really beautiful things and then to do really awful, awful things. And that I think that what's important, I found it important as a prosecutor, was to say there isn't necessarily so much different between those two extremes, that at times we might find ourselves either having committed wrongs, and we want to make sure that the system is as fair as if we were the person being prosecuted, and so that we don't strip a human being, even when they, at their worst moment, even when they commit their most heinous act, that we still recognize humanity in them. It doesn't necessarily mean they shouldn't be punished or held to account, but that we should not see them as less than human. And I think when we do that, it helps the system and it helps ourselves be better people. And so I think that's where that phrase came from.
Let's see here. Oh yeah, our new friend Stefania, who's been tuning into our programs from Italy. She has a couple of questions here. Let me see if I can I can tell that English isn't her first language, but let's see. She said, did you ever feel in your career accustomed to evil, to wickedness? Do you think that today is easier to be used to the bad things we are surrounded by? I think she's just saying, do you ever feel like you're almost jaded by the amount of,
your sensibilities are blunted, I think.
Yeah,
is a good way to put it.
That's what she was trying to say.
No, I certainly found the job to be tragic. I used to call it joyless, which is not a nice word for your day job. But in a way, it is, you're dealing with tragedy one day to the next. No one's really ever happy to see you. You're trying your best to vindicate the sort of victim's family. In a way, that they aren't your client, you aren't defending the victim, that isn't the person who you're speaking for, but our interests align usually in the sense that you're prosecuting the person who hurt that that family member. But they're at their worst moment in their lives, right? So you're trying your best to get closure for them and to be a counselor, but it's a lot of sadness, it's a lot of tragedy. The defendant and his family, they're also dealing with remarkable tragedy. The family often didn't do anything, and yet they're losing a family member, a father, or a brother, so on and so forth. They're having to come and relive the sort of heinous thing that their family member potentially did or didn't do. And then there's the adversarial part of it. You're, as you mentioned, battling someone else, a defense attorney. There are judges who have egos, can yell at you sometimes. And so you kind of feel like it's thankless. You kind of feel like you're just dealing with these sort of high-strung, morose moments in people's lives, and it can be difficult. But I found that, you just got to have a clear sense of right and wrong, good moral judgment, and know that what you're doing was right and good, and you're going to try to do the best that you can, seek justice in all that you do, and that gives you solace and comfort. But it's not for me at least, it wasn't going to be a lifelong occupation, given how tragic it can be.
It's interesting when you see, like some true crime documentaries, maybe about, famous cases, and they interview the family members of both the victims and the perpetrators, over long periods of time. They go back to revisit a classic case, and you can just see the weight that the tragedy has had on them over the years, often. Very often the killer's family or the criminal's family really get punished just because he was in their family. Or people, when the Gabrielle Gifford shooter, his family, I think his parents disappeared. I mean, they were, they fled, as I recall. Nobody could find them. What could you possibly say? Yeah.
After something like that, So I think there's a tendency today, or maybe it's always been true, to think that the relatives of the defendant must have played some role. Either they didn't do a good job, or, whereas I'm not sure that parents can always recognize what's happening. Yeah, there are people just born bad.
Yeah, I certainly think that, there are situations out of parents' control. There are, socioeconomic disparities that can push people to desperation and to commit desperate acts. And so there's a lot of unexplained variables, and we should try to do what we can to deter it from happening in the future. You want to keep people safe, while also being cognizant of the fact that people have different options at their disposal, right? People have different ways to stay out of trouble. And so we got to do our best to try to catch people early, give people the sort of baseline educational help and familial support and financial support, living wages, what people need at the beginning of their lives, so that hopefully they don't descend into criminality.
That's nature versus nurture, though. That's an argument that Robin has ever really won. I always think about Dickens. I think about Oliver Twist. How did one kid do so well from a similar place and the other one go so bad? I mean, character has a lot to do with it, as well as opportunity or lack of it. So it's all imponderable. Anything else, Patrick?
Yeah, Ben has a question. He says, let's see, by the way, he has been so impressed by this that he's gone out and purchased the book while we've been talking. So thanks so much, Ben.
Hey, Ben, thank you.
He says, having worked in politics, does Robin see himself getting into politics, presumably further, running for office? Seems very on the go, taking on challenges, and you have a great background. Do you have any political aspirations?
Thanks, Ben. I'd be interested potentially in running for office. It's something my father has always just been really interested in, the power of government doing good. I've only worked for the government. I've never worked for a private firm. Always just cared to work in the public interest since law school, from before law school. And so, if there's such an opportunity like that, I think I'd love to do it. I'm a writer first and foremost, though. This is, my lifelong dream was to write. Since I was a little boy, I've been writing stories, and so I'm really excited about this potential new career for me. So thanks for buying the book, Ben.
Which
Yeah.
gives me an opportunity to say, the bookseller in me, and Patrick will agree, you should never miss your opportunity to buy a first novel. Never miss
Behind
it,
me too.
because you just, it's a great investment, not only of your time and your emotions, but it's actually can be a great financial investment. So
Yeah,
seriously,
signed
what
first
if you
edition.
bought A Time to Kill, the John Grisham that never sold, except that I ended up buying a ton of it. And then he wrote The Firm.
Right.
I mean, Dan Brown's first book called Digital Fortress didn't have anywhere near the value of the Da Vinci Code. So, you can speculate in books, believe it or not. But anyway, I recommend that all debuts that you should really pay attention to if you're an interested reader. Would you agree, Patrick?
Yeah, absolutely.
Right, which is sort of how we built the Poison Pen over all these years.
We
So
love
Robin is
promoting, first-time authors and debut writers. That's a big, it's always so exciting, to see somebody at the very beginning, of their
It really
career.
is. We're lucky that we've done that so often. We have followed the entire careers of people like Michael Connolly, who did his first event with us and says he's going to do his last.
Oh, that's
Ray
great.
Child, all these people. That's because we've been here for a long time too. 32 years is a really almost 33, a long time to witness the rise of many new voices. So we have an opportunity here with Robin Peguero. Don't blow it. Robin, thank you very much for your time. It's really been a great pleasure to talk to you. And I hope your agent was able to tune in. And
I tried to
enjoy it
message
too.
them, letting them
So
know.
we still have autographed copies, people. So grab one. And thank you for joining us. Have a wonderful evening. Robin, congratulations again. I hope you enjoyed your publication day.
Thank you so much, Barbara. I really appreciated meeting you and chatting with you. So thank you all.
It's been great. Good night, everybody.
Night.
Hello. We hope you're enjoying our programs and podcasts with authors. We'd like to expand them, and your help would be appreciated. Please make a donation at poisonedpenfoundation.org. 100% of the proceeds will go to help connect authors with readers in this difficult time. Thank you.